What's with the Supreme Court's emergency rulings? Emergency docket cases usually involve only one round of briefing without oral arguments, and the court generally responds with a short, unsigned order, no explanation given. Until recently, this procedure was used mainly to appeal for stays of executions. However, it is being used more and more for higher profile appeals. President George W. Bush and President Obama asked for it to be used a total of 8 times in their combined 16 years. President Trump used it 41 times in his first term, and President Biden requested it 19 times over his 4-year term. Between January and August 2025, President Trump asked the Supreme Court to overturn a decision of a lower federal court using the emergency procedures 22 times. So, what's the problem? Well, there are 2 main problems. The first is that with the increased presidential use of the emergency docket, more cases of national importance are being decided without much or any explanation. Lower courts don't have enough information to apply these rulings, making it difficult to avoid similar cases ending up back at the Supreme Court. Another is that without an explanation, transparency and accountability are lost, leaving the public to wonder if the court is acting on political bias rather than legal principle. This erodes public trust, which is essential in our democracy. In a talk on July 31st, Justice Kavanaugh suggested that providing a written opinion on an emergency case could risk locking in a decision that may change once the Supreme Court hears the full argument. On the other hand, Justice Kagan said that since emergency cases are becoming so common, the court must do more to explain its reasoning. And this isn't just an abstract legal debate. These rulings on emergency docket cases can determine whether somebody loses their job, gets deported, or receives a meal at school, while the case works its way through the usual process.